Director Mueller, the President has repeatedly claimed that your report found there was no obstruction and that it completely and totally exonerated him. But that is not what your report said, is it?
Correct. It is not what the report said.
And now, reading from page 2 of volume 2 of your report that's on the screen, you wrote, quote, "If we had confidence after a thorough investigation of the facts that the President clearly did not commit obstruction of justice, we would so state. Based on the facts and the applicable legal standards, however, we are unable to reach that judgment," close quote. Now, does that say there was no obstruction?
No.
In fact, you are actually unable to conclude the President did not commit obstruction of justice. Is that correct?
Well, we, at the outset, determined that we, when it came to the President's culpability, we needed to go forward only after taking into account the OLC opinion that indicated that a president, a sitting president, cannot be indicted.
So the report did not conclude that he did not commit obstruction of justice. Is that correct?
That is correct.
And what about total exoneration? Did you actually totally exonerate the President?
No.
Now, in fact, your report expressly states that it does not exonerate the President.
It does.
And your investigation actually found, quote, multiple acts by the President that were capable of exerting undue influence over law enforcement investigations, including the Russian interference and obstruction investigations. Is that correct?
Correct.
Now, Director Mueller, can you explain in plain terms what that finding means so the American people can understand it?
Well, the finding...
Just remember this. In 2016, the FBI did something they probably haven't done before. They spied on 2 American citizens associated with a presidential campaign, George Papadopoulos and Carter Page. With Carter Page, they went to the FISA court. They used the now famous dossier as part of the reason they were able to get the warrant and spy on Carter Page for a better part of a year. With Mr. Papadopoulos, they didn't go to the court. They used human sources. From about the moment Papadopoulos joins the Trump campaign, you got all these people all around the world starting to swirl around him. Names like Halper, Downer, Mifsud, Thompson, meeting in Rome, London, all kinds of places. The FBI even sent a lady posing as somebody else, went by the name Azra Turk, even dispatched her to London to spy on Mr. Papadopoulos. In one of these meetings, Mr. Papadopoulos is talking to a foreign diplomat, and he tells the diplomat, Russians have dirt on Clinton. That diplomat then contacts the FBI, and the FBI opens an investigation based on that fact. You point this out on page 1 of the report. July 31st, 2016, they open the investigation based on that piece of information. Diplomat tells Papadopoulos. Papadopoulos tells the diplomat, Russians have dirt on Clinton. Diplomat tells the FBI. What I'm wondering is, who told Papadopoulos? How'd he find out?
I can't get into the evidentiary finding.
Yes, you can, because you wrote about it. You gave us the answer. Page 192 of the report, you tell us who told him. Joseph Mifsud. Joseph Mifsud's the guy who told Papadopoulos. The mysterious professor who lives in Rome and London, teaches in 2 different universities. This is the guy who told Papadopoulos. He's the guy who starts it all. And when the FBI interviews him, he lies 3 times, and yet you don't charge him with a crime. You charge Rick Gates for false statements. You charge Paul Manafort for false statements. You charge Michael Cohen with false statements. You charge Michael Flynn, a 3-star general, with false statements. But the guy who puts the country through this whole saga, starts it all for 3 years we've lived this now, he lies, and you guys don't charge him. And I'm curious as to why.
Well, we can't get into it, and it's obvious, I think, that we can't get into charging decisions.
Can you give me an example other than Donald Trump where the Justice Department determined that an investigated person was not exonerated because their innocence was not conclusively determined?
I cannot, but this is a unique situation.
Well, you can't. Time is short. I've got 5 minutes. Let's just leave it at you can't find it, because I'll tell you why. It doesn't exist. The special counsel's job, nowhere does it say that you were to conclusively determine Donald Trump's innocence or that the special counsel report should determine whether or not to exonerate him. It's not in any of the documents. It's not in your appointment order. It's not in the special counsel regulations. It's not in the OLC opinions. It's not in the Justice Manual. And it's not in the principles of federal prosecution. Nowhere do those words appear together, because respectfully, Director, it was not the special counsel's job to conclusively determine Donald Trump's innocence or to exonerate him, because the bedrock principle of our justice system is a presumption of innocence. It exists for everyone. Everyone is entitled to it, including sitting presidents. And because there is a presumption of innocence, prosecutors never, ever need to conclusively determine it. Now, Director, the special counsel applied this inverted burden of proof that I can't find and you said doesn't exist anywhere in the department policies, and you used it to write a report. And the very first line of your report, says And as you read this morning, it authorizes the special counsel to provide the Attorney General with a confidential report explaining the prosecution or declination decisions reached by the special counsel. That's the very first word of your report, right?
That's correct.
Here's the problem, Director. The special counsel didn't do that. On Volume 1, you did. On Volume 2, with respect to potential obstruction of justice, the special counsel made neither a prosecution decision or a declination decision. You made no decision. You told us this morning and in your report that you made no determination. So respectfully, Director, you didn't follow the special counsel regulations.
So to recap what we've heard, we have heard today that the President ordered former White House counsel Don Morgana to fire you. The President ordered Don Morgana to then cover that up and create a false paper trail. And now we've heard the President ordered Corey Lewandowski to tell Jeff Sessions to limit your investigation so that you stop investigating the President. I believe a reasonable person looking at these facts could conclude that all three elements of the crime of obstruction of justice have been met. And I'd like to ask you, the reason, again, that you did not indict Donald Trump is because of OLC opinion stating that you cannot indict a sitting president, correct?
That is correct.
The fact that their orders by the president were not carried out, that is not a defense to obstruction of justice because the statute itself is quite broad. It says that as long as you endeavor or attempt to obstruct justice, that would also constitute a crime.
I'm not going to get into that at this juncture.
Okay, thank you. And based on the evidence that we have heard today, I believe a reasonable person could conclude that at least 3 crimes of obstruction of justice by the president occurred. We're going to hear about 2 additional crimes, and that would be the witness tamperings of Michael Cohen and Paul Manafort.
Well, the only thing I want to add is that I'm going through the elements with you does not mean that I subscribe to what you're trying to prove through those elements. Over the course of my career, I've seen a number of challenges to our democracy. The Russian government's efforts to interfere in our election is among the most serious. I am sure that the committee agrees. Now, before we go to questions, I want to add one correction to my testimony this morning. I want to go back to one thing that was said this morning by Mr. Liu, who said, and I quote, "You didn't charge the president because of the OLC opinion." That is not the correct way to say it. As we say in the report, and as I said at the opening, we did not reach a determination as to whether the president committed a crime. And with that, Mr. Chairman, I'm ready to answer questions.
You also believe to be the case that your investigation was hampered by the deletion of electronic messages. Is that correct?
It would be, yes. And generally, any case would be if those kinds of communications are used.
For example, you noted that Deputy Campaign Manager Rick Gates, who shared internal campaign polling data with a person with ties to Russian intelligence at the direction of Manafort, that Mr. Gates deleted those communications on a daily basis. Is that right?
I take your word. I'm saying I don't know specifically, but if it's in the report, then I support it.
That's right, Director. It's Volume 1, page 136.
Thank you.
In addition to that, other information was inaccessible because your office determined it was protected by attorney-client privilege. Is that correct?
That is true.
That would include that you do not know whether communications between Donald Trump and his personal attorneys, Jay Sekulow, Rudy Giuliani, and others discourage witnesses from cooperating with the government. Is that right?
I'm not going to talk to that.
That would also mean that you can't talk to whether or not pardons were dangled through the president's attorneys because the shield of attorney-client privilege.
I'm not going to discuss that.
Did you want to interview Donald Trump Jr.?
And I'm not going to discuss that.
Did you subpoena Donald Trump Jr.?
And I'm not going to discuss that.
Did you want to interview the president?
Yes.
Director Mueller, on January 1st, 2017 through March 2019, Donald Trump met with Vladimir Putin in person 6 times, called him 10 times, and exchanged 4 letters with him. Between that time period, how many times did you meet with Donald Trump?
I'm not going to get into that.
He did not meet with you in person, is that correct?
He did not.
As a result of lies, deletion of text messages, obstruction, and witness tampering, is it fair to say that you were unable to fully assess the scope and scale of Russia's interference in the 2016 election and Trump's role in that interference?
I'm not certain I would adopt that characterization in total. There may be pieces of it that are accurate, but not in total.
But you did state in Volume 1, page 10, that while this report embodies factual and legal determinations, the office believes it to be accurate and complete to the greatest extent possible, Given these identified gaps, the office cannot rule out the possibility that the unavailable information would shed additional light. Is that correct?
That is correct. We don't know what we don't know.
Why is it so important that witnesses cooperate and tell the truth in an investigation like this?
Because the testimony of the witnesses goes to the heart of just about any criminal case you have.